This is an interview with Michael Conley for the SEC Historical Society's Virtual Museum and Archive on the History of Financial Regulation. Today is February 10th, 2026. I'm Kenneth Durr. Michael, it's great to talk to you again.
Thanks. Pleasure talking to you, Ken.
It's probably been 5 years or something when we first talked about the OGC.
That may be so. We did remember one with David Becker
Yeah,
about the Office of the Solicitor. I
yeah,
think that was more recent. That might
yeah.
have been a couple years ago.
That was it. I want to talk about the Office of the Solicitor for sure, and I want to talk more generally about the Office of General Counsel today. Let's dig in. First thing is getting some background. And I want to take you back to your undergrad experience, sort of see if we can unwrap the ways that you got interested in law.
Sure. Yeah, I'm happy to do that. I think I have a somewhat different path than most people to the law and the commission. And that's largely attributable to the fact that the high school that I attended, I grew up in Rhode Island. That's where I'm from. And I attended a uh, an all boys Catholic high school, college prep school that was staffed by a Catholic religious order. And uh, I love school. I always have. That's been something that's been an important part of my life. And during my time there, and as I approached the end of my high school years, where I was applying to colleges and doing all of that sort of stuff like normal, um, it really struck me that the happiest people I knew were brothers who were the people who were staffing and teaching at my high school. And I think certainly to the surprise of my parents, and in fact to the surprise of the brothers, I indicated that it was something that I might like to explore. And so at that point, I entered the community, and there was a process. Things have changed since, but at that point, it was referred to as formation, which was your undergraduate years. You'd be living in community with other people who were about the same place in the process, and it was really designed, I think, very intelligently as a discernment period. You got experience with this, and
Mhm.
to ultimately figure out if this, you know, what would have to be acknowledged to be a different path than most people, was something that was right. That there was a good fit. And I think at the conclusion of that time for me, which tracked across my undergraduate years and then an additional year beyond that, I realized that uh, although I could be very content in that life, there was a lot about it that
Mhm.
appealed to me. It ultimately it wouldn't probably be completely fulfilling for me, and so I made the hard choice, and it was a very hard choice because I figured, I entered the community when I was 17 years old, and so the people with whom I'd been living and uh, studying with were you know, very close to me. And I identified very strongly, but I decided, that that wasn't the path that was the right one for me. And so I left and went back home to Rhode Island at that point. And I'd completed my undergraduate work then. And so the question, naturally arose, like, what am I going to do?
Mhm.
And I talked to my parents about it. And my stepfather was an attorney, and he said, you can do whatever you want to do, but one possibility might be to go to law school. You love school, which was true,
Right.
and he said, you know, whether you want to ultimately be a lawyer or not, there's a lot that goes on there about how one thinks about things and solves problems and so on and so forth that you could probably put to good use no matter what you decide to do. And my stepfather was a Boston University BU law alum, and so took me there, met some people, walked around, and I decided that it made sense. I didn't have anything else,
Right.
better in mind at the
Right.
time. And so I decided I'd give it a shot. And as it turned out, I mean, it was great. He was exactly right. I did like it. I got very excited about it. And I think the the really was such a good experience is at least in substantial part attributable to the excellence of the faculty there.
Did you have
Um,
any influential professors, anything like that?
I did. I mean, I would say, and I had the great good fortune, like every place else, we were split up into sections first year, and we basically moved in lockstep through the sort of foundational courses. And I mean, for torts, I had Colin Diver. For contracts, I had Clark Bice, who had been at Harvard and then retired from there and came to teach at BU as well. I had David Sipe for property. I had Bob Bone for civil procedure, and these are all like major. Some were pretty new at that point. I mean,
Mhm.
Bob Bone and David Sipe were quite new. I mean, they taught. I had been at law firms, but they were beginning their teaching careers. But obviously, Clark Bice was at a very different point in his, as was Colin Diver. And it was great. I mean, I loved it.
Yeah.
And they were very inspirational. Clark Bice actually was one who really encouraged me to, at that point, I didn't know precisely what I wanted to do even as I was finishing law school. And I figured, in fact, I would probably stay in Boston. I had done, summer clerkships at law firms there and seemed like that was a path. And, I knew clerkships were a possibility, but I wasn't really, focused on that. I was on the law review. I was editor in chief of the law review.
Okay.
So that, again, that's sort of a crowd, where people are all comparing and what are they doing in terms of clerkships.
Right.
And Clark Bice really encouraged me. And at that point, I'd also had him for administrative law, which is what he's really known for beyond contracts. And really, he brought that to life. He had been there in the 30s when a lot of stuff was just getting going, and of course, has a textbook, Bice and Hornbook on administrative law. And he had suggested that the DC Circuit would be a place that I might want to look. And he wrote letters of recommendation for me. And ultimately, I was selected. I had the great good fortune to be selected by Abner Mikva to go there. And so that's what I did. I left after I finished law school. I went down to Washington, fully intending to come back to Boston. I had already accepted a position at a firm in Boston at the time, Goodwin Proctor,
Mhm.
and so it was going to be temporary. I was just going to go down, do my clerkship, come back. Of course, things don't always work out the way you imagine, and working with Judge Mikva was great. He had experience. At that point, he had been in Congress before he was appointed to the DC Circuit by President Carter. And so he had really just, I would say, like an insider's view of what happens in Congress and a great respect for the legislative process. And so that was something that he brought to his judging. But I will say after this, my good fortune continued because after clerking for Judge Mikva, I was selected to clerk for Justice Blackmun. And once again, just an incredible person and judge. And I will say that both of the folks for whom I clerked were excellent judges, but they were even better people.
Mm.
Their approach and the thing that sort of distinguished them for me. I'm sure there are other judges, do this, but I knew both of these people was how conscious they were always of the effect on people, real people, of the decisions that they were making. I think I've known other great judges. I mean, brilliant men and women, but I don't know that there's always that follow, and maybe it shouldn't be. There are certain circumstances in which the law is the law, and you kind of have to figure out what the right answer is, even where it will have some negative effects on some discernible individuals. But at least thinking about it, being conscious of it at the time you're making the decision, I think for them helped shape the way in which they approached cases. And
Hmm.
so, and in fact, as I was thinking about today and talking to you, I was, and you had mentioned maybe we do some of my background stuff, and I thought one of the cases that Justice Blackmun decided, and it was a couple terms before that I clerked, but I think it really captures for me just who he was as a judge and as a human being. And it was the DeShaney v. Winnebago County case. I don't know if you remember that one, but it was about the failure of this county in Wisconsin, the Child Protective Services Bureau, to protect a child from a violent parent. And the upshot was the majority of the court held that there was no right of action under Section 1983. And Justice Blackmun dissented. There were a couple others who dissented as well. Justice Brennan, I believe, Justice Marshall probably dissented as well. But Justice Blackmun wrote a separate dissent. And I don't know if you let me just read like a couple of sentences from that, because I think it really, for me, captures him. And so this is what he wrote.
Sure.
He wrote, and this was not the first paragraph of the dissent, but second or third, I think. And he wrote, "Poor Joshua, victim of repeated attacks by an irresponsible, bullying, cowardly, and intemperate father, and abandoned by respondents who placed him in a dangerous predicament and who knew or learned what was going on, and yet did essentially nothing, except, as the court reveals, dutifully recorded these incidents in their files. It's a sad commentary upon American life and constitutional principles, so full of late of patriotic fervor and proud proclamations about quote unquote liberty and justice for all, that this child, Joshua DeShaney, now is assigned to live out the remainder of his life, profoundly retarded. Joshua and his mother, as petitioners here deserve, but are now denied by this court the opportunity to have the facts of their case considered in the light of the constitutional protection that 42 USC section 1983 is meant to provide." And, I read that and I can totally hear him. He didn't write every word of decisions that, in which he was designated as principal author. These were his words. He wrote this, and it really does, I think, capture just who he was as a man.
Yeah. And an approach to law that maybe, not in the ascendant right now, I think.
No, and if anything, I think some of the words in what I just read, I
Yeah.
think could well apply.
Yeah.
You hear a lot of rhetoric that's very highfalutin, as he would have said, but when push comes to shove, it doesn't always have. There's not the follow through.
Right.
So
Right. That's great. Well, let's get you started on the road to the SEC.
okay,
You went into practice for a little while, is that right?
I did actually for quite a while. I mean, I would have been I clerked in for the DC Circuit 89-90 and then Supreme Court 90-91, so OT 90. And so in 91, in October of 91, I started at what was then Pillsbury, Madison, and Sutro, now has morphed several times through incorporations of other firms. Um, and and my decision about where to go, I interviewed at a number of different places before deciding, and ultimately picked Pillsbury because it had a very substantial presence in San Francisco as well as in Washington. And I had not decided. I thought where I wanted to live and practice was in one of those two places, so
Hmm.
that it would be helpful to have a firm that had presence, in both.
Yeah.
And so I started out in the Washington office, and as happens in life, the longer I was in Washington, in my personal life, I developed relationship with someone, and uh, that turns out not to be the person that was ultimately, the person with whom I have a continuing relationship. But I met also my then partner, now husband, like within a couple of years of leaving the court, and he's from here. I have East Coast origins, as I told you, and so
Yeah.
our families are fairly close to here. So I decided, that this was going to be the place that I was going to make my life. But that was the reason for Pillsbury at the outset.
Yeah.
And so
Didn't
when
make it to San Francisco though.
I would spend a lot of time in San Francisco because Pillsbury, San Francisco based. And
Okay.
so, and a lot of the clients for whom I did work and so on were California. I was in California courts a whole heck of a lot, the
Okay.
Ninth Circuit, any number of times. And so, and my practice was sort of a typical, I would say, appellate, legal issues type practice. Some of it was appeals. Often I was involved in, complex commercial litigation where I would be involved in the case, sort of from the get-go, to assist in, framing legal issues and in doing things like summary judgment motions and, so on, to sort of position a case that if it ultimately were to go on appeal, we want it to be, as well situated as possible. And so that's what I did. That's what my practice was. I will say that after a few years, I became a partner, and within a year or so of that, they asked if I would serve as managing partner for the Washington office, which I agreed to do, somewhat reluctantly, honestly. Um, and it was a lot of administrative stuff.
Yeah.
And so by the time, it was the end of the 90s, that was what I was doing. I still did, I would appear periodically in cases and I would supervise some stuff, but really I did a lot of administrative stuff.
Yeah.
And so it was in the beginning of 2000 that I was approached by a law school friend of mine who also lived in DC and I saw periodically, Arthur Levy, who is now a professor at Rutgers Law School and has been for a number of years and is an expert in investment management law in particular, but securities law generally. And Arthur was then at the commission. He was in the Office of the General Counsel, and he called me and said, what would you think about coming to the commission? There's this new program, the Jennings Attorney Fellow Program, and you might think about it as something that you'd be interested in trying. And I said, well, Arthur, I'm not a securities lawyer. I said, sounds like fun, but I'm not a security. He said, that doesn't matter. He said the program's designed to bring people in who are, along in their careers, not newbies. And the idea is that you can bring, whatever skill set you have in practicing law. Mine would be, appellate litigation,
Mhm.
um, and pick up essentially this extra, interesting area, which would be securities law, in a way that a lot of people don't get to do. You'll get an insider's view. I mean, and you can do it for a limited period of time. The fellowship was designed to be for an initial 2-year term of appointment, potentially extended to 4 years. That's the way it was structured.
Hmm. Was that pretty new at the time? The
Yeah,
Jennings
it
Fellowship?
was new. It was new.
Okay.
I believe Professor Jennings had died the year before, maybe 1999 is my recollection. But I was sort of an inaugural member. Probably not a good one because I didn't do the, stay only 2 years or 4 years and then, go back to the firm. And that's what I thought I was going to do. I mean, I took a leave of absence from my partnership. I didn't, quit the firm. And they were, I think, pleased to have me do it with the idea that I would be coming back. But in any event, I came. I worked in the Office of General Counsel and in particular in the appellate group. And really, right from the beginning, I mean, was involved in just incredibly interesting things. And happily for me, I had returned basically to the practice of law myself, right? So I was writing briefs and arguing cases and doing all the stuff that I really liked to do with zero administrative responsibility at that point. I didn't have responsibility for anybody. I was being supervised. So it was like the old days for me,
Yeah.
and that was very welcome.
Who
And
was doing the supervising?
well, it would have been the folks who were the assistant general counsels in the office in the appellate group, and then ultimately Jake, who was the solicitor.
Okay.
But there were between Jake and me was one of the four folks who were the assistant general counsels.
Okay.
We referred to as the SK-17s, which means nothing to anybody else in the world probably besides us. But that's what that means. You're a manager without being a senior officer.
Okay. We'll talk about some of those experiences, generally speaking. What, I'm assuming you kind of worked your way up through cases, through different levels of complexity. Is that how it happened?
Yeah, I mean, not different, I guess, meaningfully. I started at probably a higher level, right, because of when I came in, where I came in. But essentially, yes. I mean, as I said, securities law wasn't my background, so I really needed that exposure and getting up to speed. It's a code-based practice, effectively. There are a set of laws that and regulations that are applied. There's a you know large but not insurmountable body of law, case law that had been developed over the years. So it's something that I was something of a generalist before I came, and so I was familiar with you have to get up to speed to the relevant law and facts and so on of whatever it is you're dealing with, and I was just doing that every time. I didn't have something to fall back onto in terms of cases that I'd already done. And it took a while to build up that because I asked, and Jake was very helpful in being willing to do this. Uh, I wanted to try lots of different things, and so I didn't want to become the expert in, the 33 Act or something. I mean that wasn't what I had in mind, and he really accommodated that. It was a wonderful opportunity to work closely with uh, all the folks who were managing me at the time. Very accomplished lawyers. They were you know, terrific. I mean, I will say that Jake, having the opportunity to work with Jake as closely as I did, was a real gift. Um, it's certainly you've heard this before, probably countless times from people who worked with Jake, but he was really one of a kind. He was, it's funny because he was born in 1934, and people used to joke about it and say, "Yeah, he was created by the 34 Act, same time as the agency." But he came to work at the agency in June of 1962, which was 6 months before I was born. So there really was talking about generational kind
Yeah,
of thing there. And he was unique. He had the incredible recall. People always joke about his office being a disaster, which
right.
to anybody, an outside observer, you'd think so. You walk in and think like, oh my God, what happened in here? Did something explode? However, he might be talking to you and some issue in the case that, we were discussing, had come up before, and he would stop for a minute, look up, go over to one of those many piles, reach down into it, pull something out, and sure enough, it would be a brief in a case from, 5, 10, 15 years earlier where the issue had come up and we had used it. So he was his own kind of, random access memory. He had that going on, long before there was a computer capability for doing it. Thank goodness there is computer capability because I lack that
Yeah.
skill. I never had it, and certainly, he was just, unique in that way. So it was great to work with him.
What were some of the formative cases that you worked on when you were coming up?
Um, there were a number of cases over the years. I will say uh, I did some work, for example, in auditor independence rules cases. That was an interesting thing when I first came to the
Mm.
commission. The commission was dealing with that, and it was, this is Arthur Levitt was still chair. It was the very end of the Clinton administration and second term, and the auditor independence was something that he had been very focused on,
Mhm.
and honestly met resistance on both sides of the aisle. You know, the auditing firms,
Yeah.
really had substantial support kind of across the board. And then, of course, you had, Enron and Arthur Anderson and WorldCom. I mean, all of those, major collapses that gave rise to substantial litigation, but also sort of proved that the wisdom of his suspicion about, auditing firms both being the ones who were responsible for conducting the audits that were necessary, to certify, and selling, you know, assorted services to those very same companies.
Yeah.
I mean, it was obvious, and certainly he saw it, and I think others really, were turning a blind eye to the conflict of interest there. And so
Mm.
I will say that those were interesting cases that I worked on.
Okay.
And you know, other things that happened at that time. I mean, you probably will get to, it was, I guess I had been at the agency almost 10 years at the time that the Madoff scandal unfolded. And that was huge, obviously.
Yeah.
It really kind of, and just not in terms of uh, dollars, it was, I mean, the biggest fraud that people had seen to that point. But it was really an existential moment for the commission itself.
Right.
I mean, you had, uh, a huge miss, right, by the agency, that all these people who were devastated. Um, and he was involved in the kind of thing where our folks were supposed to be, you know, in his offices, not
Right.
infrequently, right?
Right.
And simultaneously, you had, in retrospect again, it's possible to know, but there were folks who were coming forward and saying like something's not right here. You know, Markopoulos is the probably
Yeah.
best known of these folks, but it was really, it was hard. I think, in speaking to people who were running the agency at the time, I mean, Mary Shapiro came, that's what greeted her when she
Right.
walked in the door, right, as chair in, you know, 2009, January 2009, she came on board. Um, it was she was remarkable. She was really an incredible person, and I think back on that. I mean, it's I think a matter of record that she testified before Congress more times than any other chair,
Mm.
to that point and since. And during her period, she didn't have the longest tenure. She was here for 4 years, which is normal, but she was there a lot.
Yeah.
And and it was necessary both for that audience, principally Congress, right, but others as well. I think to show that we as an agency, could learn from this and do what was necessary in order to get better. You
Right.
know, and one of the things, for example, that she came up with that's I think been a rousing success is the whistleblower program. I mean, that came into existence, I mean, because of that, right? Because of, you know, somebody having come and the agency not responding in a way that would have been most helpful. And so the whistleblower program got up and running under her, has resulted in huge, you know, information gains from whistleblowers, and I think on balance, really changed the dynamic, inside a
Hmm.
lot of these companies, and people, understandably, I think, who are in the know often are, terrified that they'll lose their livelihood and there'll be no way for them to continue if they do the right thing and come forward and you know announce that this is what's going on, blow the whistle
Right.
technically, but that was what's necessary. So that's a great thing that Mary did. And also, at that point we were dealing with Dodd-Frank. It
Right.
was in the wake of the financial crisis, and you couple that with Madoff and Stanford and so on and so forth. It was a very busy time, but the
Right.
Dodd-Frank period, was incredibly busy. It just, the agency was assigned by Congress a record number of rulemakings to complete
Right.
in a record short amount of time, right? I
Mm.
mean, and they have gone simultaneously. It's I you have to assume that Congress had some sense of what the agency's staff was in terms of sheer numbers, but it was all out.
Yeah. Let's jump into uh, sort of an offshoot of that.
Okay,
Though all that rulemaking went through the General Counsel's office,
that's right.
as well as the divisions. And I want to get a sense, you're in the appellate side, and I want to get a sense of how much you interacted with the other folks in the General Counsel's office.
Well, I mean, the answer is a lot.
Mhm.
I will say that I mean, it wasn't unique. I mean, periodically, typically, let me explain it that way.
Mhm.
Typically, within OGC, it was the legal policy group that worked with the rule writing divisions, and it's kind of a check. They were,
Right.
the divisions do what they do, but the OGC, had people who were, very expert in administrative law, and in the substantive law that was going to be involved in these rules. And they would, work sort of together with the divisions to make sure that what ultimately was put out for notice and comment, and then, responding to the notice and comment and working on the adopting release, uh, was as good as it could be, as accurate as it could be. I think when you had all the stuff that was going on with Dodd-Frank and these other things on the margins, which were sort of raising questions about the competence of the agency as a whole, the appellate group got involved in a more substantive way earlier in the process. And so we had people who would actually be assigned to the various rule writing teams,
Okay.
which formerly, maybe you call an appellate person for a one-off question, or at the very end, you might sort of, to the extent that there are people out there who are threatening to sue, if the rule is adopted, you'd want to let the appellate folks know that. But this, now it was much earlier. And so that really diversified the work of the appellate group. It sort of multiplied the work of the appellate group, to be
Mm.
honest, right? Because the other things, the sort of, when I first came to the agency, I think it was much more traditional appellate work, which I will say is, appeals that are taken from federal district court cases, or appeals of commission decisions or orders. That's what, the true bread and butter and the bulk of the work was that was being done by the appellate group. As the need increased for appellate involvement, early appellate involvement in rulemaking, that changed, and people needed, the group was expanded somewhat, but it was very busy.
So the Madoff period, the Dodd-Frank period was when this happened, when the
Yeah, I would say in
OG.
combination. it wasn't because of Madoff, but Madoff just happened to be like plunked right in the middle of when Dodd-Frank was being implemented, right? So, and Dodd-Frank, I'm sorry, Madoff, if you wanted to say like why and why would appellate have some involvement in it? Why did I have any involvement in it? I mean, it was largely, I think, attributable to the fact that the appellate group had as one of its areas, and this is just sort of a relic of history, bankruptcy. So overseeing bankruptcies of public companies. And so there were always people in the appellate group who were part of the bankruptcy subgroup. And one of the things that the bankruptcy subgroup was also involved in was bankruptcies of broker dealers. And the statute, the Securities Investor Protection Act of 1970 and the Securities Investor Protection Corporation, or SIPC, which was created by that statute, was responsible for that. They handled, in the first instance, they handled broker-dealer bankruptcies. And this all came out of the late 60s, the back office crisis, all of this sort of stuff, where it was really just a disaster. When some of these firms went under, I mean, people thought they had money in their accounts or securities, and they didn't.
Yeah.
And there was nothing. They were stuck. I mean, they could try to sue the firm, but if the firm is gone, I mean, what are you going to get? I mean, so it was really a very important piece of legislation and an important entity that was created. And we were very involved with them. And so Madoff was the biggest broker-dealer bankruptcy ever. And it was a disaster, at Madoff. Mm-hmm. And so there were all kinds, because it was also just a complete fraud. It wasn't as if, there were just, somebody at the broker-dealer firm was engaged in transactions without getting authorization from the client. Those are like typical things, right? And so when a firm goes under, there's some stuff there, but there's other stuff that isn't, that should be, and so on and so forth. His was a complete, he made it all up. I mean, he was printing out these things that were not connected to anything. I mean, it was completely fabricated. Right. And so when the statute is designed, to make sure that folks who are customers of the broker-dealer have what's supposed to be in their account. But the assumption is there are real transactions that are occurring or that could have occurred and just weren't, or something happened after the fact and money was taken and so on. But there's a real thing that's going on with the market that was not Madoff. No. And so you had to confront a circumstance where, the only sort of real thing you could look to was the money that was being invested and the money that was taken out. And so they would buy these customers. And so that money in, money out was ultimately what was adopted. And what we concluded as a legal matter was the only supportable way to read the statute. Mm-hmm. But it was horrible for these customers because they were operating under the assumption and living a life, predicated on the idea that what they were getting, these, totally bogus, statements from Madoff were real, including like paying taxes on, it was
yeah, I never
really disastrous.
Yeah.
And just, I mean, crushing for these people. And it was a horrible position to have to take, I will say. I went and I testified in Congress about this.
Right. And you testified about assets. Basically, you're trying to figure out what to do with Madoff's assets, right?
Right.
Yeah.
And to the extent that there were assets, right? And there was also the coverage that existed under the statute. I mean, that was the protection that these customers got. But it wasn't anywhere near enough to cover the losses that most of these folks were suffering. So, but the idea was, yes, do we count these fake transactions as if they were real or not? And once you decide that you can't count it as real because there's nothing there, that left these customers in a very difficult position. I think it's the correct legal conclusion, but it was a hard position to take. but it's the one we did. And my testimony was at least in part about that.
Tell me just the experience, what it was like preparing to testify before Congress and actually doing it. I would think that it was sort of an all-consuming experience.
Very stressful at a minimum, right? I had never done it before. There were people who are really good at it who do it all the time.
Yeah.
And I had a challenge too. And we had great help from the folks, in the chairman's office and elsewhere, who knew how to do this stuff, our legislative, relations folks. And, and they, at the beginning of we had these prep sessions and so on, they call them murder boards.
Right.
You have a bunch of people line up pretending to be members, and always, they would pretend to be like the most difficult member. And so they'd be asking you all kinds of stuff. It's like, ugh, who wants to hear that? But it's better to hear it, from people on your home team
Right.
than hear it the first time when you get there. And the difficulty that I faced initially was I was an appellate lawyer, right? I go to court, I argue cases. I'm entirely familiar with judges on a panel asking me questions and responding to them. The thing that I needed to have drummed into me, and it took a little while, was they're asking questions. They don't care a whit about what it is you say. This isn't about you. This is about them. And so, sometimes you just have to let the questions roll, and if they're cutting you off, that's fine. Because once again, it's not about you. And it's a totally different process. This isn't it's not a fact-finding endeavor or, a way for you to persuade them of the correctness of the position that you're articulating. That might happen at the margins, but that's not what this is about. And that was hard. And
Okay.
like I said, I think it was harder for me because I had something that was like kind of similar to this, but just entirely different in terms of purpose and the way it worked.
That's really interesting. I'm not sure anybody's ever described it that way before.
Well, there are other people who are probably a lot better than I am at going and testifying to Congress. I mean, as it turned out, I think it went okay,
Yeah.
except for, as I said, the folks at the other side of the panel who were testifying on behalf of the investors who had lost, for whom I was like, this demonic figure, and that was bad. That was
Mhm.
hard. It was right in terms of the things that we had to say, I think, but still very difficult.
Somewhere in this period, you become deputy general counsel.
Yes.
How did your work change at that point?
Um, it changed a lot. Mark Kahn was the general counsel at this point, and Mark had been deputy general counsel before becoming general counsel. And then for a brief period, Annie Small was deputy general counsel. And then she was asked to go to the White House counsel's office. And so, understandably, she left that position and went to White House counsel's office. And at that point, Mark asked me if I would consider serving as deputy. And at first I said no. I said I like doing what I'm doing. This is really what my work is. And he said, well, you'll still be, responsible in this capacity for the appellate group. It'll just be different. You and Jake will swap positions. You'll be his supervisor. And I love Mark, and so I said, okay, I'll do it. And so, but at that point, the office was organized differently than it is now, and there were only two deputies, and one deputy was responsible for part of the legal policy group, which did the rulemakings and so on. Very, very busy
Mhm.
position. But the other deputy was responsible for everything else. And so included in that was the general litigation group matters, which are incredibly diverse. Everything that's not securities law that an agency has to deal with, personnel issues, leasing. I mean, it's just like, you name it. when the agency itself gets sued, like for things that it's done, or alleged to have done. I mean, they have all that stuff, right? And it's stuff about which I knew nothing. But I found myself, again, now I was kind of a new deputy at this point. And before that, I'd been accustomed to being really hands-on, I was, deputy solicitor. So I was, Jake's sort of follow-on person. And I had responsibility for a lot of what was happening in the appellate group, but I had sufficient time to be able to really get in and dig in to the things that I was responsible for. That was no longer true.
Mhm.
And even if it would have been true, I wouldn't have known what to do because this was totally foreign law to me. And so that took up a huge amount of my, and it didn't help that there were all these crises that were going on that fell under the umbrella of that group at the time that I first became deputy, including like the leasing debacle, and it was like there were all kinds of things that were just
Wow.
really bad. And so anyway, it was taking up a lot of my time. So consequently, I was still responsible for the appellate group, along with the part of legal policy that did enforcement review and the adjudications group. But I just didn't. I was very thinly spread, put it that way.
Mm.
And I got better at it, as time went on. But at one point, sort of toward the end, and I'll tell you a story, but it's when Mark was there, he really liked the general litigation stuff. Mark Kahn did,
Mhm.
which was great for me because he would often be willing to just sort of himself, directly handle this stuff, and um, and it really became sort of the our operating uh, understanding that I wasn't going to be doing that stuff anymore. I wasn't going to be focused on that. There was enough other stuff for me to look at, and he would just do that directly. And when Mark left the agency, uh, the next general counsel, that was when Mary Shapiro left, and then Elise Walter became chair, and her general counsel was Jeffrey Aronow. And Jeff is great. I know Jeff well. He was really fun to work with. But when he came, he was looking at the org chart and said, "Okay, I get how this other stuff works. Why is it that the general counsel is responsible for the general litigation group instead of you?" I said, "That's the deal." And so he always jokes about that. But he came in and he was the recipient of a deal that had been struck before he got there. But what happened subsequently was the responsibilities got divided up. There were more deputies. Now there's a deputy who's responsible for general litigation.
Okay.
It,
About when did that happen?
it was gradual. Different deputies got added, but it was while Annie Small was there.
Okay.
Most of it happened then. And yeah, so.
Oh, great. Okay, that's important, and I hadn't known about that. Um, so you're still looking at the appellate group. I mean, was that the
I
main
was.
thing that you were doing?
I mean, I probably spent more time with the appellate group because it was my stuff.
Mhm.
But as I said, I was also responsible for, the part of legal policy that does enforcement review. Those are the two main parts. I mean, and maybe I should have clarified that earlier. I talked
Mhm.
about the part of legal policy that works with the rule writing divisions, um, and they're, incredibly important and have a huge responsibility. There's also the part of legal policy that does enforcement review.
Okay.
So, every matter that enforcement begins starts with a recommendation to the commission. The commission has to authorize it. And before any of those recommendations go to the commission, they go through the enforcement review component of the legal policy group within OGC. And so that, which is incredibly interesting, I will say, it was having that involvement. They would have meetings every week calendar meetings, they were called, where you would review the stuff that was coming up, and it was a great way for me to learn a lot about what happens and what the cases that were coming down the pipe. Because, as I said, I mean, enforcement stuff had to go through that group before it went to the commission, and and so they're also incredibly important. But then there's also the adjudication group, right? That does, drafts commission opinions, and so that was a component as well.
Okay. Moving through this period, the 2010s, I guess, were there common denominators to what you were looking at? Were there things happening in the economy and securities industry that, you know, sort of led you to deal with certain types of cases or certain types of challenges?
Yeah, I will say certainly the beginning years, a lot of it was Dodd-Frank related. There were challenges to rules and so on. There were the rules that had to be written in the first instance, right? And adopted by the commission. And then there were challenges to those rules. And I will say that, I don't know if you want to start to talk about cases now, and what one set of cases that I think was significant were the cases involving challenges to the commission's economic analysis of
Yeah.
rules. That that started really kind of about while I was still deputy solicitor. The economic analysis challenges.
Mhm.
The first of those. Does this fit with your
Yeah, yeah, no, we were
your
moving right
plan?
into that. I think that, one of the big landmarks here is that you became solicitor. Um, when
Right, and
was
that was
that?
a little later. So
Okay.
that's why we probably missed this
Well,
this
let's,
kind of
yeah,
stuff that I was working on. But because I think it was one of the, if I had to think about, areas that were consequential
mhm,
during the time that I was there, I would say that there were really probably three big ones. And one of them, the first of them, is the role of economic analysis in commission rulemaking. And
okay,
that's the first one that came along. Uh,
okay.
I don't know if we want to
Yeah,
take a little
let's jump
break
into
here.
it. Okay. That sounds good. Let's take about 5 minutes and
Okay,
then we can come back and start talking about a lot of really interesting cases.
terrific. Okay,
All right. Well, we got you to running the appellate group. I want to talk a little bit about how things changed when you became deputy general counsel and then when you moved up to solicitor. Can you take me through that transition?
sure. Well, first, as deputy general counsel, that was, as I mentioned, Mark Kahn had asked me if I would fill that role. I agreed to, initially reluctantly, and I became accustomed to, I think what everybody who takes, as you take higher positions in an organization, typically you realize that you're responsible for more, and you have to spend a little less time on each thing that you're responsible for. And so
Mhm.
that took some time for me to get accustomed to that. I ultimately did. I mean, he, as I said, was very, very helpful in assuming responsibility essentially totally for the general litigation group and all of the things that were happening within their ambit. Um, but then otherwise, I was, there. And so among the things that I would do in that position was to attend the commission meetings, the closed commission meetings.
Okay.
Um, I would be there often, speaking about, enforcement matters and other things that were happening. And so that was a major change in my responsibilities and my access, to people who were making these decisions. I was there every week, so I heard everything that was
Mm.
going, in the close. Well, I mean, there might rarely be something I wouldn't be in the room for, but by and large, I heard everything, that was going on with the agency. And so I don't think there's a better way to get a sense of the wide range of things that come before the agency and how carefully the commission works through things. I've
Mhm.
often thought, that the Sunshine of the Government Act has, real good use and good, certainly it was well intended.
Yeah.
Uh, I think that a lot of, what happens at the commission can't, for good reason, be done in the public. And there are, exceptions to the Government of the Sunshine Act for that. Among those are everything that occurs in a closed commission meeting. But in some ways, it's too bad that people can't see just how much deliberation there is and how hard people think about, the questions that are there. These aren't sort of snap decisions. I think sometimes there's a sense that that's what goes on, and it's very much not that.
Yeah.
I will say that at least a part of that, an important part of that, I think, is the bipartisan nature of the commission's composition. Because when you have that, it's much more likely, not exclusively, but it's more likely that you're going to have, harder questions to respond to from whoever happens to be, on the other sort of wing of the commission at any given point. And I would say that it's my judgment that the work of the agency is better when people have to answer hard questions, or they have to think about them at a minimum. And that was one of the things that I was very impressed by during my time serving as deputy general counsel. But that was a big part of it. That was the biggest difference, I think, was being in that room.
Mm. So you had a very broad perspective in this period, it looks like. Did that help you when you became solicitor?
I think so. I would say that even though my focus narrowed,
Mhm.
in the sense that I was back to doing appellate work and being responsible for appellate work, um, the I didn't. I knew more now. I knew how things worked, and periodically I'd go to closed commission meetings, but in any event, I think um, I had broader relationships across the agency to draw on. I will also say that the way I became solicitor, okay, we've sort of alluded to this, but haven't really talked about it, is that Jake retired. Jake at that point had been solicitor for decades and had been at the agency. As I said, he came in 1962, and he didn't retire until 2015.
Mm.
Uh, I think 2015, 2016, and so he'd been there a very long time. And when he retired, uh, and Annie Small was the uh, GC at that point, and I went to her and said, that appellate work is really my love, and I would very much like to, be moved into Jake's former position. And she, obviously, she's a brilliant lawyer. She was a great GC and also a really good person. Understood that and said, okay, but, if you're going to do that, I want you to stay part of the group that we refer to it as the front office. It's the sort of smaller group of senior officers in the Office of the General Counsel who meet with regularly and advise the GC on the countless difficult issues that the GC
Mm.
has to confront. So I
Mm.
remained part of that group, which was a different thing than had been the case previously. And
Really?
so, and then sort of a component as well when, after Annie left and Bob Stebbins became the GC. I worked very closely with Bob. He's another excellent GC. I've been so lucky, I have to tell you. I know that there are other folks who, wouldn't have as good things to say, maybe, about who it was that supervised them in different parts of the agency. But GC has been very, very fortunate to have incredibly talented people and people who are willing to work closely with and rely on those who have been there a while. They put their egos to one side in order to be able to offer the best advice to the agency. And I think that Bob was clearly one of those people. And he basically decided that my position then of solicitor would be a direct report to the GC. There wouldn't be, appellate would not be under another deputy.
Okay.
So that sort of wound up formalizing what Annie had begun by having me remain part of that front office group. And so, yes, so then I was responsible for the appellate group again, but I was also part of the sort of general group that was, batting around and trying to come up with ways to resolve various issues that were arising.
Okay, so when Jake was running things, he was sort of had his own little shop over there on the side. Is that how it worked?
I think that's a way to think about it. I mean,
Yeah,
Jake was obviously, a counselor broadly, and when people would call him, he was more than happy to take the time necessary in order to, help them with whatever it was. But that wasn't his regular job.
gotcha.
His regular job was appellate.
Okay. Well, your regular job was appellate too.
Yeah,
Although
I
you
called it,
were,
but I had this other stuff
yeah,
kind of still hanging
yeah.
out. Um,
Let's talk about the
okay,
cases. This discussion of structure has been great. But let's talk about some of the cases that you were dealing with both before and after you became solicitor. And we started to talk about those a little bit ago, but let's talk about the economic analysis.
okay,
I remember the Chamber of Commerce decision.
right.
The,
Yeah, that was a big decision in 2006, right? And it was really one, I like to think of them as the trifecta. And I will tell you, first of all, full disclosure here, the cases you're going to hear about are not cases in which we won.
right.
It's often the case, right? Is that the ones that have the greatest impact are cases that sort of shake things up. And that's really what I would like to talk to you about. I mean, the first set of these cases is economic analysis. The second is the approach to disgorgement. And the third is sort of things ALJ. In all three situations, you're talking about a substantial shift in the way the commission had looked at things, and frankly, the way that courts had looked at the commission and its role previously. So, just starting with the economic analysis cases, as I said, I think there's a trifecta of DC Circuit cases that came in sequence that dealt with economic analysis. And the first was the Chamber of Commerce case in 2006. And in that case, the Chamber was challenging a rule that it was an exemptive rule that required mutual funds to have boards that were 75% independent directors and also have an independent chair in order to be able to engage in certain transactions that would otherwise have been prohibited by the Investment Company Act. And so that was the rule that the commission adopted, and the challenge came. And the chamber came in with a whole bunch of different arguments, a lot of sort of authority challenges that the agency just can't even do this. And the court rejected all of those. I mean, they were substantial challenges, but the agency prevailed on those. However, and Judge Ginsburg wrote this decision. Judge Ginsburg, sort of a major player in all the economic analysis cases that I'm going to talk about, he was a former head of OIRA. which is the Office of Information and Regulatory Affairs within OMB. So he knew this stuff. I mean, he was really, this was something that was very important to him, economic analysis. But he was also very familiar of necessity, given his role, his pre-judicial role, with what happened with executive agencies. And with executive agencies, OMB has a very, it's a very involved, they're involved in everything with the rulemaking.
Right.
And they have formal cost benefit analyses and so on. So in this case, this first case that came up, as I said, the court rejected all of the sort of big ticket, authority cases, agency, you can't even do this. They said, no, the agency can do this. It can play in this space. However, it concluded that the rule didn't satisfy the APA for the reason that the agency hadn't adequately considered the compliance costs for the rule and the proposed alternative that had been presented to the independent chair condition. And Judge Ginsburg wrote that. And in so doing, he looked to what we call the ECCF provision, which is efficiency, competition, and capital formation.
Okay.
That was added to the SEC's statutes by NISMIA, the National Securities Markets Improvement Act of 1996. And that provision said basically that whenever the agency is engaged in rulemaking and is required to consider whether a rule is in the public interest, it must also consider the potential impact on efficiency, competition, and capital formation. So that's how it got into the statute. It had only been there for like 10 years at this point.
Right.
But this was the first time that the court actually interpreted that and said, well, what does this mean? And Judge Ginsburg wrote that what it means is that when the SEC is engaged in these rules, it has to inform itself, the public, and Congress of the likely economic consequences of the rule that it's considering. And so this is, and said further that the agency, even in difficult matters, has to do what it can, that's what the court, what he said, to inform itself of these impacts. And
Right.
so it was kind of injecting, I think, a bit more of traditional cost benefit analysis, certainly than the agency had understood. The agency was considering it, but this sort of affirmative obligation to go out and do more was something that came from this case because it's not in the statute. This is a reading of the statute, and it's one that was set out, I think, first in that case.
What was the response when you realized that this was really gonna reset the stage? Did you?
I don't know that the agency really realized it at that point.
Oh, really?
Yeah, I think that because they're words, and that was this case, this rule. Who, I think for a while at least, and this is where these other cases become more important, right?
Okay.
It's not quite clear exactly what that means.
Okay.
So the agency, had historically, done efficiency, competition, capital formation analysis post 1996, but they were like a paragraph, sometimes a footnote that was in the rule saying we have considered the likely impact on efficiency, and we believe that efficiency will be increased or decreased.
Okay.
It wasn't a full-blown, I think, analysis of the sort that you would find in traditional cost-benefit analyses, like OIRA would see routinely and require of executive agencies.
All right. Well, let's move into the next two components of the trifecta.
Right. So you have the American Equity case in 2009, which was actually my case. I argued that case. And it was about the fixed indexed annuity rule. And that was a rule that the commission adopted that classified certain fixed indexed annuity products as securities rather than insurance. And in this space, the big deal is, are you going to be subject to the securities laws, or are you going to be subject to the laws of state insurance regulators? And not surprisingly, the insurance industry wanted to be regulated by insurance regulators instead of securities regulators. And so there was this fight. This American Equity insurance company brought this case. And the DC Circuit, once again, Judge Ginsburg on the panel, rejected all of the statutory interpretation arguments that were made. So all the big stuff, the stuff we thought of as the hard stuff, the court said, no, no, no. The agency can do all of this. Everything it's doing, it can classify these things as securities, so on and so forth. However, once again, the court said, but the agency tripped up when it had to do its economic analysis because it didn't adequately assess what the state of regulation was under the state's insurance laws. So in other words, what does making these products subject to securities laws do to, what's the delta? And unless you know that delta, you can't meaningfully analyze the likely effect of this rule on these products. Which, in retrospect, I say that's fair. That's kind of not an unfair thing to do, but it was brand new. This was not an argument that was made by the challengers. This was something that, Judge Ginsburg thought about and concluded was a necessary component. Again, sort of well beyond what the agency, I think, had ever imagined. I mean, to go out and have to survey every state's insurance laws, and I mean, it's a mammoth undertaking and probably disabling, truly, in terms of just resource allocation to be able to engage in rulemaking in this space. Right. And this is where the agency was starting to say, like, if this is what it means to do an economic analysis, do we have the resources to engage in it? And if we don't, are we just sort of out of the rulemaking business in, a lot of what we do? One of the things that was never disputed, I mean, there was, I think, really general agreement on this, is that, when you're doing these analyses in the financial regulatory space, they're particularly difficult because there are so many factors that come into play and so many uncertainties, and how, various sort of market participants are going to respond depends on how other market participants respond, and what things are that we don't even know about yet, and so on and so forth. So it's hugely difficult, but we're being told that you have to do it, and in this case, you have to do it for every state. So that was just saying, like, forget it. This is just not doable, and that was something that I think came as something of a shock to folks, but not enough of a shock, because there was yet to follow was the Business Roundtable decision, right, which was about the proxy access rule. And interestingly, of course, this was a rule that was part of Dodd-Frank. I mean, the commission had explicit authorization to go ahead and engage in this rulemaking. It wasn't one of the mandated rules, but it was one in which authorization was provided. So there was zero question about the agency's authority to be in this space. So really, the turf over which the people were going to be fighting was the adequacy of other things, and chief among them was the economic analysis. And this was like the coup de grace from the trifecta of decisions, which this one was also a decision that Judge Ginsburg wrote. He didn't write the American Equity decision, Judge Santel did, but he was on the panel. And he asked the critical question of me, about a lot of the stuff. And one of my initial answers was, that's not an argument that's being raised by the other side. And he said, I know, but let's just, consider this. And so in any event, that happened. And then Business Roundtable's proxy access rule, famously, right, this is a rule that was designed to provide, a certain category of substantial long-term shareholders an opportunity to uh, get their own candidates for the board on the company's proxy, right? So it's a more powerful. They could do it. They could do their own, submit their own proxy. But in terms of actual likelihood of having impact, this was huge. This was going to happen. And as I said, the no real authority challenges here. It would have been hard after Congress explicitly gave authority, but this was the most devastating of the three opinions on economic analysis because Judge Ginsburg went through and analyzed why the rulemaking had inadequately considered possible effects. I mean, the court went on to itself assess the relative reliability of studies that the agency was relying on, just way beyond what anybody would have imagined a reviewing court would do, where an agency had itself, reached conclusions about the basis. I'm not saying the rule was perfect by a long shot, but there was just a tenor in the opinion and an approach that was taken, which just said, like, kind of all bets are off. At this point, I mean, I don't know what we're going to be able to do. And so that was the decision that I think really brought home to people that, is the agency ever going to be able to, adopt a rule that survives challenge? Because the DC Circuit was, for all intents and purposes, our home court, for challenges that would be likely to be brought. And if these rules are consequential in any way, obviously the people who are, going to be affected by the rule, it's in their interest to challenge it and to challenge it there and to challenge it on this ground.
Yep.
Right? And so that, as I said, was really sort of it. And at that point, proxy access was dead, and we all kind of got together. There was a meeting at the White House with all relevant agencies, and there was enormous concern. But we, ourselves decided that what we needed to do was to find a ground on which we could live and answer some of the concerns that had been raised in these cases without basically surrendering and making ourselves an executive agency where you'd have to do full-blown cost-benefit analysis that essentially would bring rulemaking to a grinding halt. Mm-hmm. And so those were the things. And so instead, we came up with what still exists and still is used, was the staff guidance on the use of economic analysis in SEC rulemaking. And we, in our office, and what was then called RISC-Fin, but is now DERA, the Division of Economic and Risk Analysis, got together and came up with this guidance for rulemaking. So it's staff level guidance about how to take, like, what are the critical components of economic analysis that we can incorporate in our rulemaking to make them better rules that answer a lot of what these cases and some negative, IG reports, and let me think what else, members of Congress had sent stuff to us saying basically that, the only way this is going to work is we're just going to take the SEC and put it under the OIRA system. And that was a real thing. I mean, it was entirely possible that that could happen at the end of the day. And so in order to not have that happen, we came up with this, which was a way to say, we hear what you're saying. We want to do serious, rigorous economic analysis, but we can do it in a way that will work within our rulemaking structure as an independent agency. And we did that. And every chair since at that time has, Mary Shapiro was the chair for the first one, and then every chair since has endorsed using that guidance in rulemaking.
Okay.
So that was I think, a success story that emerged from, because it was successful because there subsequently weren't successful challenges to rules on this basis.
Right.
So it actually did work, but it was also kind of a PR thing. I mean, it was real. You saw
Mhm.
it, you saw it in our releases, but it also said, we hear you, you
Right.
know, we get it, but we are an independent agency. And so this is a way to do what's necessary and to answer these concerns while still enabling us to carry out our mission.
Right. So Judge Ginsburg really reshaped the SEC to some extent.
Very much so on that front. Yeah, I think that's true. I
Yeah.
think that's
All right, let's move on to disgorgement. These we're getting into some even more, I think, notable cases here. Cases
yeah.
that people know the names of these cases.
And
So did
so,
yeah, go ahead.
I'm sorry, go ahead. You have,
Did disgorgement start with Kokesh?
it was Kokesh. That was the first of the big cases that we confronted. And remember, disgorgement was a long-standing remedy for the agency. I mean, going back, into the 60s, it was courts were awarding disgorgement, which was, a way to remedy wrongdoing by taking the unjust enrichment away from the wrongdoer, right? And courts saw this as a component of their remedial authority to enter injunctions. So, which was clear and had a long standing, right? That was from the very beginning. Courts can enter injunctions, and along with prohibiting people from engaging in the misconduct again, what this was it was effectively injunctive relief, compelling the wrongdoer to cough up the unjust enrichment that they
Right.
got from it,
Yeah.
right? So that was the theory that was behind it. In Kokesh, the agency, this was a 2017 Supreme Court case, the agency had sued Kokesh for concealing the misappropriation of funds from business development companies that he managed. The district court awarded disgorgement for the violations which began back in 1995. So it was like 14 years of violations, something like that. And it rejected the argument that it should be capped at 5 years under the statute of limitations in Section 2462, because the court said that disgorgement wasn't a fine, penalty, or forfeiture, which was what was necessary in order to qualify for 2462 coverage.
Hmm.
So the 10th Circuit affirmed. This is consistent with what everybody had thought, at that point. Certainly we had at the agency. And the Supreme Court unanimously reversed in an opinion by Judge Sotomayor, saying that disgorgement, for purposes of statute of limitations at least, is a penalty. And the idea was it's a penalty for two reasons: because it remedies the violation of a public law as opposed to just some private transaction, and it's punitive. That was the critical one, right? Because it is intended to deter as well as, and it's not exclusively, compensatory. So that, for the court, led them to conclude that it was punitive and therefore a penalty, and therefore subject to 2462, which means you can only go back 5 years, which is a big deal. I mean, that was huge, for the agency. There was also ominous footnote 3 in the opinion, which said basically, we're talking about statute of limitations here only. We are not resolving the question about whether the SEC statutes authorize disgorgement when you're in a federal district court action. And the court went on to answer that question in the next case, which is Liu, 3 years later, is 2020, which was an EB-5 case where the petitioners solicited foreign nationals to invest.
What was that
in
case? An EB-5 case?
EB-5, yeah, these are these where foreign nationals can, if they contribute a certain amount of money to projects in the U.S., they can get visas. I mean,
Okay.
it's long-standing program, and so
Gotcha.
that's what these people were told, right? But their money was supposed to go to build a cancer treatment center. whereas in fact, most of the money was misappropriated by the people who were, you know, enticing them to come.
Okay.
So the SEC brought a case seeking the total amount of the funds that were raised in this fraudulent endeavor. And the district court ordered that, and the Ninth Circuit affirmed. And in the Supreme Court, came back to the question, right? This goes back up now, and can in SEC cases can courts award disgorgement? Where is that authority? Where is that rooted? And the court, by an 8-1 opinion, also written by Justice Sotomayor, said disgorgement is available. Okay, so this one, I said they were all losses. This one isn't a loss, but it's not, or at least not a total loss, because the court said that it's authorized as equitable relief, and then the critical language for the benefit of investors, but it has certain limits that are rooted in that language for the benefit of investors. First, unlike the SEC's longstanding practice, disgorgement wouldn't automatically be sent to the Treasury. In most cases, it would have to go to harmed investors. After all, for the benefit of investors, what does that mean, right? And then second, joint and several liability for disgorgement, which was also very common, was no longer available because it was punitive, and you can't hold somebody accountable for money that they didn't get without it being punitive. And so therefore that wouldn't be available either. And finally, the court must deduct legitimate business expenses. Now, of course, each of these things have lots of got to figure out what that means. There are going to be exceptions. The court acknowledged that. And so that really has been playing out since. I mean, those questions are still ongoing. So that's disgorgement, which is, another sort of, everybody thought they knew what it meant. Everybody thought they knew what the agency could get. The agency thought it knew what it could get. And it turns out it's totally different than what had been known previously. And then the final sort of area, I think, of consequence, and a really big one, as you said, people know these decisions, is in the ALJ space.
Yeah.
I'll just say very quickly that, Dodd-Frank sort of changed things in lots of ways. And one of the things that Dodd-Frank did was to expand the range of cases that could be brought by the agency administratively, and cases that previously the agency had to go to federal district court.
Mm-hmm.
And I think, and others have said this, so it's not some brilliant revelation that I've come to, but that it really, when certain people were being brought in house, certain kinds of cases, they were significant enough, the cases were significant enough, and they had the resources to mount challenges of a whole range that I think previously, the agency was unlikely to see. And among the challenges were these constitutional challenges to the ALJs in a variety of ways. The first of those was a Lucia case in 2018. The commission had instituted administrative proceedings against Lucia, charging that he had engaged in securities fraud in connection with the promotion of what he referred to as buckets of money investment strategy. I always thought that was a kind of a questionable choice, but in any event, that's what it was referred to. And the ALJ issued an initial decision finding liability and imposing sanctions. Lucia sought review by the commission, making the argument that the ALJ was an officer, constitutional officer, who needed to be appointed under Article 2, which hadn't happened. The commission rejected that argument, and on appeal to the DC Circuit, the 3-judge panel that first heard it unanimously rejected the argument, consistent with Landry case, an earlier DC Circuit case. And the en banc court looked at it and split evenly. So the consequence of that was that the panel decision stood, the commission decision stood, but of course they went to the Supreme Court. And because in the interim, the 10th Circuit had entered a decision saying basically they agreed that
Mm.
these were officers. And so the Supreme Court, Justice Kagan, uh, wrote the opinion in the case and said basically that it was an easy case, that ALJs are constitutional officers based on an earlier decision in Freitag, which interestingly, or ironically, you might say, was a decision that came out during the term that I was clerking at the
Mm.
court and was written by Justice Blackmun. It was one of the every sitting, Justice Blackmun would take one case, basically, which he would do all on his own. We normally assisted, did
Mm.
drafts, did all this sort of stuff.
Mhm.
Freitag was one of his cases. So he did this one on his own. And he reached the conclusion that the court reached the conclusion that these special trial judges of the tax court were constitutional officers based on the fact that they had an office that was a continuing office that had been created by statute, and they did important things. Basically, they were acting essentially in the same way that a federal district court judge
Right.
does.
Right.
So it's appropriate that they, be understood to be officers and required appointment consistent with Article 2. And the court said, you look at these special trial judges, you look at ALJs, there's basically no difference. If the STJs are officers, so are the ALJs. And
Mhm.
so that's what they concluded, and said that consequently they can't just be picked like any regular employee, they have to be appointed by the commission. So that was the first. And then surrounding that, right, are all sorts of other constitutional challenges that are emerging to the ALJs. I think this kind of opened the door, and people saw, that just because people thought things worked a certain way forever doesn't mean that's true. And
Mm.
you have, courts that are increasingly suspicious of administrative agencies. They are particularly suspicious of administrative agencies that are adjudicating matters on their own without having to go to federal district court. So let's look at these ALJs, and the Jarkissi case comes along.
Mm.
And so several of those constitutional questions were raised in Jarkissi. Here again, you have a circumstance where the commission institutes administrative proceedings against someone who's managing investor assets, charging them with fraud. And ultimately, the ALJ entered an initial decision finding fraud. The commission rejected the constitutional arguments that were raised by Jarkissi, and Jarkissi appealed to the Fifth Circuit. I will say there's a little detour here that happened before the agency decided it. He decided to go. Jarkissi went to the DC Circuit to try to challenge on these grounds. The DC Circuit rejected the challenge. So he came back to the agency. So this was a long case.
Mhm.
But it was a consequence of challenges that he was raising. And so goes to the Fifth Circuit, figuring why not? DC Circuit isn't too hospitable, but let me try the Fifth Circuit. And the Fifth Circuit was a much more hospitable place for him. They actually accepted all three of his constitutional arguments for why the case should be tossed, and said it was a Seventh Amendment violation because this kind of case needs to be brought in district court. It was a non-delegation violation because there's no discernible principle on which the commission is deciding whether to bring a case in district court versus administratively. And finally, there's a separation of powers problem because the ALJs are insulated from removal. They have two layers of insulation from removal, and that is impermissible. So you go to the Supreme Court, and Supreme Court decides the case exclusively on the Seventh Amendment ground. It acknowledges that the Fifth Circuit ruled on these other bases, but said Seventh Amendment is enough. Once again, the court says easy case, because in this case, it's the nature of the case is such. It's a case that's challenging fraud and seeking civil penalties. And both of these things are things that were known at the common law And so therefore it checks the first box for things that need to be brought under the Seventh Amendment
Mhm.
before a jury, and additionally, it doesn't satisfy what had come to be known as the public rights exception to that Seventh Amendment requirement, which is a longstanding, but the court acknowledged is kind of opaque at a minimum in terms of what falls within the public rights exception, what doesn't fall within the public rights exception. And the majority said this doesn't fall within the public rights exception. It is really something that just literally looks like something that would have been in common law court, and in so doing, the court gave really short shrift to the Atlas roofing case, which we, along with other agencies and courts forever and ever, had understood to mean that Congress can decide to assign something to a non-Article 3 court, and this is precisely the kind of thing that this is. But the majority said no, and so therefore that left the commission in a situation where this kind of case it just can't bring administratively, and so really substantially constrains the docket for what can be brought administratively, and really just undid what, at a minimum, undid what Dodd-Frank had done in terms of expanding the scope of things that could be done administratively.
In a case like Jarkissi, where it's moving slowly and you can watch this thing unfolding, were you in the solicitor's office sort of thinking about strategy all the time, figuring out, how you might respond or adapt to
Absolutely.
what's happening?
Yeah, no, it was critical, right? Because there is sort of non-acquiescence exists as a doctrine where if there's one court, in one circuit that decides something, so long as the agency can bring matters in other circuits, or there are other parties that can bring matters in other circuits, and it wouldn't necessarily have to go to that circuit. You can be circumspect about it, but you don't have to like shut everything down.
Right.
If it were the DC circuit that decided something, that's a different ballgame, right? Because everything can go to the DC circuit. And but in any case, once the Supreme Court had taken the case, as a practical matter, the agency wasn't going to be authorizing any new proceedings of this sort, right? That
Right.
the court was considering. But I will say two things about the decision in Jerkissi. One, I think everybody was shocked that the court went out on this Seventh Amendment ground. We were really worried about, because of Atlas roofing, we really didn't think the Seventh Amendment, we thought that was like, come on, what are you kidding?
Yeah.
And of course, that's the one the court bought. But the separation of powers thing, like the removal, we had concerns about that.
Okay.
Didn't think that the court would bite on the non-delegation thing. Were it to do so, that would effectively upend, administrative agency authority in a way that I think people hadn't even really conceived of previously.
Mhm.
But so we really thought it was the separation of powers thing. Everybody was surprised. The folks at the SGs who were working on the case, the deputy SG who argued the case, really didn't see that one coming. And
Yeah.
so that was something of a surprise. But yes, we had to respond in real time. And I think substantially limited the ultimate impact of the case by really reducing in a big way, the number of cases that might otherwise have been in the pipeline.
Okay. So your career as solicitor is very interesting because you're sort of in this interface where the courts are reshaping the SEC. Did you see yourself as responsive more than having agency of your own?
I have to say, I think we were largely in a responsive mode. So much stuff was coming at us. Now we did strategize, as I indicated,
Right.
and try to anticipate ways that decisions can go in order to the extent possible, limit the negative impact on the agency's agenda, and that happened, I think, as I said, quite effectively in the economic analysis space.
Mhm.
Others were harder. Nothing we can do about, yes, the ALJs could be appointed. I mean, yes, and that ultimately happened, right? But in terms of the Seventh Amendment,
Yeah.
nothing we can do about that, right? I mean, they're not juries in ALJ proceedings. I mean, that's not going to happen.
Right.
So certain things, I think, yes, there was a wave that was moving and that grew over time, that really sort of overwhelmed, I think, the SEC. We were sort of unfortunately at the leading edge of a lot of these cases. I mean, this didn't affect us only, obviously.
Right.
Uh, Lots of administrative agencies that are living with the results of these cases. But I mean, looking back, are there things the agency could have done to avoid this? I suppose if it had been more circumspect about the kinds of cases that it was bringing administratively after Dodd-Frank created that authority, that might have done it. Might have, who knows? It might have at least postponed some of these issues coming to the fore. But Congress gave the authority, so it's kind of hard to say, in light of that, um, why the agency wouldn't exercise authority that it had expressly been given.
Right.
But in retrospect, yeah, that might have changed things. Some of the results, I don't know. I think there are other things in play here where the administrative state writ large, you have lots of people out there who are suspicious about it, including judges,
Right.
including many judges who've been on the Supreme Court for some time.
Yeah.
And so I think there's only so much you can do. And so you are of necessity going to be responsive.
Right.
Uh, you get the decisions and you do what's necessary to implement them. And you try to help the agency come up with ways to, do so while not entirely undermining their regulatory or agenda. And so that's what we worked on. We've worked very closely with the divisions and the commission itself to try to make that a reality. But it's hard. I mean, I
Right.
confess that it's a difficult time. I mean, I think if you took somebody from the agency in 1978 and plunked them down in say 2024 when all of these decisions had come, I think they would be shell shocked. It's just what happened.
Right.
Everything we thought we knew to be true is now up for grabs. And I mean, and so, looking forward, you sort of say, well, what's on the horizon?
Yeah.
And the truth is, I don't know. Um, I think we're going to have to try to continue, as I said, you have to live within the law. And so there are these decisions. There's also what these decisions portend, perhaps in other areas where you have folks who are similarly suspicious, and you do your best. That's what we do. The commissioners are the ones who make the decisions. The operating divisions are the ones that initially formulate policy that they're proposing to the commission. And OGC's job is really just to assist all of those actors, all of those players in accomplishing their mission in a way that is consistent with what we understand the law to be and most likely to succeed
Mhm.
in, facing challenges which are inevitable. It's the one thing there's always going to need to be
Yeah.
an OGC.
One thing we haven't talked about is amicus briefs. There, that General Counsel in 1978 would have had a fairly strong amicus program.
Right.
Was that the case when you were solicitor?
Yeah, well, I think it's useful to think about how does commission amicus participation occur?
Mhm.
You know, two main ways, right? One is that a court invites / orders the commission to supply its views. And the biggest of those is Supreme Court, right? Anytime there's a case in which the Supreme Court requests the views of the Solicitor General, which happens all the time, that involves securities law issues, the SG immediately sort of hands it over to us. And so in the first instance, we would be, and I mean people in the appellate group, consulting with others within the agency, would take a first crack at it. Talking to the SG, I mean, Malcolm Stewart has been our deputy forever and ever. So Malcolm and I would talk about it and we'd get some sense, do an initial sort of, what do you think about this? Where do you think the agency is going to land? What's the best way to approach it? But then we would, meet with the parties. The SG would invite both sides in, ask questions of them. We'd have a discussion again about it. Then we would go back and ultimately do a draft. We would do the first draft, working with the SG. In that circumstance, it is the SG that's appearing in the Supreme Court. It's the SG that has to be taking the position. It does so in consultation with the commission, but ultimately what happens is the SG, shows the commission, listens to what the commission has to say, but ultimately says, okay, this is the brief we're going to file. Do you want to be on it? And the commission votes whether or not to have the commission's name included. When it's not in the Supreme Court, we have stuff, most of the time it's come from the Second Circuit, requesting the SEC's views. But in that case, remember, it's going to be a case in which the commission hadn't previously participated. Most often going to be a private case. So we would on our own do the same sort of thing that the SG does. We invite both sides in, figure out what we think an answer would be, draft something up, talk to the commissioner's offices about it, but ultimately submit a memo saying this is what we recommend the commission do in response to this court's request. If the commission ultimately votes what's going to happen, if the commission authorizes participation, it tells you what position. We draft it and we file it. That's the way it works on the court side. Then there's the, people coming to the agency, participants in the case, private parties, and asking the SEC to participate. And that is, there's a whole process for that. People it's on the website.
Yeah.
They can submit requests for amicus participation. Those come to whoever the solicitor is, and typically another person in the appellate group, usually another assistant general counsel, and it's reviewed. I mean, most of them, candidly, people want SEC participation. It really doesn't make sense. One, because it's not an issue that we are ever going to confront or that we think necessarily would make sense for us to weigh in on. Also, because people sometimes submit requesting that you file a brief next week. And, the amicus process is just really different. And that's sort of the biggest point I think I would make, is the process. I started to talk about it where, we would review this thing. If the appellate folks think, yeah, this might be something that, the commission should weigh in on, you invite the parties in, the parties talk to you, you figure it out, you talk to the relevant folks within whatever operating division is going to be implicated by this position. You have to get their views. We have to write it up. We have to send it to the commission. The commission has to vote because it hasn't previously participated in this. So all of that takes that's before we even write a brief,
Wow.
and then we have to draft whatever it is that gets filed, assuming the commission supports the recommendation to participate. That takes weeks at a minimum, if not months. And so frequently people ask for stuff that's simply not doable as a practical matter.
Yeah.
And so I would say that one of the big things I always try to tell people whenever it's at a conference or something, like, come early. If you think you might want the SEC to be involved, there's no guarantee that it's going to happen, but it will definitely not happen if there's not enough time to actually do it, because we have to do that process. We can't just file something without the commission really thinking through it and authorizing participation.
Okay. So it sounds like there's a big resource issue here, where you really can't pull people off of things that are more pressing. All those things we were just talking about.
I think that's true. I mean, the you have to find resources if the Supreme Court asks you or if the Second Circuit asks you. You know, you just do.
Yeah.
We have to do it. It's one of our things, right? And obviously, the Supreme Court's decision in these cases, you know, frequently it's in a private action, but not infrequently, what the Supreme Court says about one of the statutes, will also affect us. And so it's hugely important that not only because the Supreme Court has asked, and do we obviously want to respond, but because real world impact, comes from these cases, and we need to pay attention to it, and we need to give the resources in order to respond. But you're right that it really does. That has a limiting effect. That and all the other things that we've been talking about
Yeah.
that our office is doing. There's only so much that we can do, and so there may be matters. I don't think there were many matters that I thought where we received a request, and I thought it was something that it would be good for us to participate in, and we had time to do it. Where we said no,
Okay.
not many. There really aren't many.
Okay.
I can't even think of one, to be honest, off the top of my head. So.
Something else I want to touch on before we wrap up, and that's you were acting general counsel for a little while, and we know how much you love administrative positions. Tell me about the
I know. How
challenge.
about this? My path, right? I come to the agency in an effort to escape all the administrative stuff, and ultimately I wound up there anyway. Um, so, yeah, I mean, I was acting GC for probably a total of about 7 or 8 months in 2021. I agreed to do that when Bob Stebbins left. Um, he asked if I would do it, and the new folks asked if I would do it. I thought it would be for a shorter time, um, and then after about 6 months, I said to the chief of staff for the chair, remember, I have a day job, and so they said, yeah, 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 yeah. And so John Coates came and was general counsel for a couple months.
Yeah.
There was never the idea that he was going to stay long term, but at least it freed me up to go back and do my
Okay.
solicitor stuff. And then when John went back to Harvard, as he was always going to do, I again assumed the role of acting general counsel until Dan Berkowitz arrived, which
Right.
was sometime, I think, November, maybe early December of 2021. And that was it. That was my tenure. So I was kind of an easy person to pick for it because I'd been around for a long time. I knew
Right.
everybody. The commissioners knew me.
Right.
And so in a sense, that was easy. But it's never something I aspired to.
Yeah.
It was
Did
kind of
things
like
look different at all when you were sitting in the general counsel seat? Or was it everything just what you expected? You'd seen it all before.
I can't say that I had necessarily seen all of it before. It was the beginning of a new administration, right? So, and Gary was just starting as chair. So, and he had a huge agenda already. He
Yeah.
walked in with all kinds of stuff that he wanted to accomplish. So I hadn't dealt with that. That was new, and I was dealing with it, right? At the start, because there were all kinds of things that had to be done just to keep things on track for him and his timetable and so on. And so that was new. That was new. A lot of it, because as I said, I've been around for quite some time, like closed commission meetings. I mean, all that sort of stuff. I was very familiar with all of that
Yeah.
and that process. And so I don't think I was shocked by anything, but it was busy.
Yeah. Well, this has been great. I've really appreciated sort of getting into the nuts and bolts of things. Um, it comes at the end of this project where I've been studying the OGC's office. So, um, is there anything else that springs to mind that we haven't talked about?
I don't think so. I mean, I think it's probably clear from what I've said, that I consider myself to be extraordinarily fortunate to have been able to be at the agency and especially work with the people that I have worked with. I mean, it really is a unique group of folks. I mean, people who throughout the government, I think, who have experienced our agency in some way or other, you know, typically say, it's a special place, and OGC is a special place within that special place. And so it was great. When I just to sort of come full circle, when I entered religious life and while I was there, I mean, one of the things that I found most satisfying and most attractive was the fact that, I had the sense that what I was doing, teaching and what I would have done as a career had I stayed in that community, was something of genuine value, and that I was surrounded by people who had a zeal for that same mission, the same, whether it's, teaching students in school was the mission then, and doing so in a way that was, really sort of a fulfillment of something that moved me. I found that, again in the agency. I don't know. I mean, who knows? Like these random things, that occur. I said, Arthur Levy called me and
Yeah.
asked me this. It happened that, a very close friend of my husband and me, died in late 1999. And when Arthur called it was one of those like lift up your head moments. Otherwise, who knows where I would be? Almost
Right.
certainly not here, and I wouldn't have been here for 25 years. And so it's really been great. There have been challenges. We've talked through a
Yeah.
number of them in recent years. Who knows what the future of the administrative state is, and independent regulatory agencies and so on. But at least I have confidence that the folks who I know, who are continuing to pursue this mission are doing so, with a genuine desire to get it right and to be of service. And so that gives me great satisfaction.
Well, terrific. That's a great place to wrap up on.